Okay, I see we have Mr. Chapman and Ms. Reese. Ms. Reese, I believe you are here on behalf of the appellant, correct?
Yes, Your Honor.
Okay, and would you like to reserve any time?
5 minutes, please.
All right. Go ahead, counsel.
Thank you. May it please the court, counsel. My name is Rachel Reese, and I represent the appellant Ernest Cherry in this matter. The case before this court is a case that almost reminds me of an example of when we're learning about the principal theory and the felony murder rule in law school. Chike Tim was an individual that was planning and ultimately executed the crime of burglary on the home of Courtney Mallory when unexpectedly Mr. Tim was shot and killed right at the doorway. The obvious suspect, Mr. Tim, was no longer a possible defendant, and the state of Florida wished to prosecute someone for the crimes, and that someone ended up being Ernest Cherry. Now, there were 4 arguments that were raised in Mr. Cherry's pleadings, but I would like to start with issues 3 and 4 as a focus for today's argument, and they kind of go hand in hand. And both of the arguments deal with the totality of the evidence that was presented by the state of Florida and the trial court's failure to grant Mr. Cherry's motion for judgment of acquittal, and then later his motion for a new trial after the jury found him guilty. Now, one of the main points that these 2 arguments have in common is the position that the state of Florida failed to prove that although Mr. Tim had a clear intent and plan to commit a burglary of this home, the state did not prove that Mr. Cherry was involved with the burglary, had any intention to participate in it, or assisted in the execution of the actual crime. At the time of his trial, Mr. Cherry, it was argued that he was entitled to a judgment of acquittal because the state's case was entirely circumstantial and they had not excluded the reasonable hypothesis of innocence presented by him. Of course, since his trial has concluded, the Florida Supreme Court got rid of the...
Before you go on, Ms. Reese, can you detail for us what was the reasonable hypothesis of innocence that was conveyed by Mr. Cherry at the trial?
Of course. And I think that's actually important, even though that's not the standard anymore. I do think that it still applies to the standard now. The reasonable hypothesis of innocence was looking at the evidence in the light most favorable to the state. Mr. Cherry, his cell phone was in proximity to the location. The argument was that he was there. So the reasonable hypothesis of innocence was that he was simply dropping off Mr. Tim, a friend who had no vehicle, who constantly and consistently asked people for rides, and he had no idea what he was dropping him off for. And I think that still goes to the fact that it supports the argument that the state never proved what was known, which is hard to prove, of course, but there was no witnesses that directly tied him to it. So it was based on a lot of circumstantial evidence and a lot of inferences. And the evidence that was presented to support those inferences just doesn't pass the muster.
Well, in the state in this case, even given that, the state in this case portrays this as putting the pieces of the puzzle together, that it's not just simply this hearsay evidence here. I mean, we have a little bit more evidence that we have Mr. Cherry obtaining a different car on the day of this event, telling a story to the person he took the car from, that this car was he didn't want his probation officer seeing his new car. And when this car is seen on video footage, while he's not necessarily seen, shortly after we have a phone call to another witness conveying that Mr. Tim has been shot, which the only way to know that at that time that he had been shot would have been if he were there. We have the cell phone pings, and then we have him telling a story to Ms. Bonaparte to report that the car had been stolen. So, I mean, there's a little bit more evidence than just some complete circumstantial evidence in this case.
And I think that, as you said, Your Honor, putting the puzzle pieces together, I think that was the only way that the state was ever going to be able to try to establish this case. And again, looking at the evidence in the light most favorable to the state, there are puzzle pieces. However, what the trial court even said at the end of the argument was that this case is a stretch. And I think that's where this is important, is there can be puzzle pieces, but when there are pieces so significant missing, that is reasonable doubt. And the state has a burden to prove all the elements beyond a reasonable doubt. And again, we don't have the same standard.
But the standard at the time of the judgment acquittal, and I don't know if you're going to the new trial motion, but to the standard at the judgment acquittal would have been in the light most favorable to the state. And so given the evidence that was laid out by the state, the motion for judgment acquittal should have been denied.
I respectfully disagree, only because I think that although there were pieces of evidence that, even again, looking at them in the light most favorable to the state, the evidence also failed to, for example, Your Honor pointed out the fact that a phone call was made to one of the witnesses after this incident happened. And I even went back just to make sure that I wasn't just imagining things. The witness never even specifically identified that how he was reached out by Mr. Cherry. He said that he received a phone call. He didn't say on what phone number, things like that. So again, we know that he made a phone call. We don't know if it was his phone. And again, the ping close to the proximity of the crime, obviously, like most favorable to the state, it puts him there. However, it doesn't explain why he was there. And I think that's the biggest problem. Without evidence of what his knowledge was and what his intent was, if he wanted this crime to happen and he was actually assisting Mr. Tim, that's where the state's case.
Okay, and so then this plays into the hearsay evidence that you complain about with respect to Mr. Edwards. And I think it's your position that the only connection that they had Mr. Cherry to the crime would have been the statements that Mr. Edwards overheard the victim talking to Mr. Cherry, correct?
Correct.
Okay, and so that's that would be the connection, would it not?
That would be the connection. And okay. the what was overheard was the mention of a lick. And again, the witness testified that a lick normally means robbery. It could mean a burglary. And evidence, like most favorable to the state, the assumption or the understanding is that was Mr. Cherry on the other end of that, because then he was picked up. Whoever was on that phone call, the argument was that they were the one that actually picked up Mr. Tim at the gas station. However, again, we don't know what the context of that call was. We don't know the context of that statement. We have no idea that statement that Mr. Edwards overheard had anything to do with a plan that was being discussed for that specific day. And I think that's, again, it's questions that weren't answered, and those questions lead to more than reasonable doubt.
Well, we certainly know that there was some sort of nefarious acts by Mr. Cherry here, where he's telling Ms. Bonaparte that he's borrowed a car to go see his probation officer, and then he tells a story that the car had been stolen, which it had not been, right?
I don't believe that the evidence ever established that it hadn't been stolen, because I know that it was missing for quite a while afterwards. And again, I can't dispute that
there was no evidence that the car had been stolen. I mean, there's no report that was ever made. There was no, the lock wasn't jimmied or anything.
Correct.
He just brought it back, basically, kind of how it played out.
Correct. And again, those things are, of course, the inferences that can be made from them are troubling, but our position is so that doesn't prove beyond a reasonable doubt that Mr. Cherry had the intention to help this.
But this is arguing the JOA. I mean, that gets us past the JOA. Okay, so to the motion for new trial. So if I understand it correctly, there's some statements that the court says, hey, this is a closed case. And he finds it significant, he or she, and I can't remember, he finds it significant that the jury was out for a short period of time, and that based on the evidence that was presented, he then says, I deny it on that fact. So, and I'm paraphrasing, obviously, but what about that says that the court used the wrong standard?
So obviously there's a lot of cases that were cited in the briefs. There is no magic words. They don't have to sit there and say specifically.
But clearly when the trial court says something to the effect, and I think a lot of the cases cite this, that says something like the sufficiency of the evidence. I think the appellate courts have come down and said, hey, that's definitely the wrong standard. We need to send this back to the trial court to use their appropriate standard. I don't see that kind of language in the ruling that the court makes. And so I guess my question is, reading the rule, are there cases that say if the court doesn't say what the standard is, that's error?
So it doesn't say that they have to say the specific standard,
Okay.
but I think one of the cases that's helpful is it's a case that was cited, I believe, by the state, and then in our reply brief, which is Bell versus State. It's from the first DCA from 2018. And the facts in that case are actually kind of similar, which is why I think it's helpful. The trial court was given a similar motion for new trial, and in denying it, the court said the motion is denied. We dealt with this at the trial, and they continued to go on through what the evidence had been at the trial. And the court said that the trial court made no mention of applying the weight of the evidence test, and the fact that it had mentioned the trial and having already dealt with the issues, it alluded to the sufficiency of the evidence standard, which I think is similar to our situation. The court doesn't have to say that they're using the manifest weight of the evidence.
But wasn't that argued by defense below? I mean, wasn't that the standard that was argued? So it wasn't, the court wouldn't have been any misconception of what the standard would have been when the court was denying.
That is correct. However, in all these other cases as well, the same things were also at issue. All the attorneys also argued that it was the weight of the evidence under the rule, and that the court had to consider it under those matters as well. And what the Bell case says, the court doesn't have to say those words specifically, but when there's a question about it, which I think that there is in this case, at least, if not obvious on its face, then it has to be sent back so they can reconsider the motion for new trial and make a determination at that point. And I think, and again, the focus in our situation is the fact that I believe it was Judge Ward said that she found it significant that the jury was out for such a short period of time, and that they did that.
But that's just a comment. I mean, that's just a comment about that's just a comment about how short a period of time it took the jury to convict him. I guess inferring from that there was so much evidence there in the case. Without necessarily saying that, but she doesn't misquote what the standard is.
Right, but and I guess the point of the argument is not that she ever misstates it. And a lot of the courts that have reversed and sent a case back to reconsider this issue, a lot of them don't misstate it. A lot of them just offer statements that are similar to the ones offered in this case that give the illusion or the question of whether or not they use the right standard. And the reason that this is such an issue in this case is because the fact how long a jury is out for and the statement that they were out based on the evidence presented is arguably saying that I'm going to deny your motion because obviously the jury thought he was guilty. The jury was not out for very long. The jury clearly didn't need to sit here and deliberate for hours. So the jury got it right. And that's the basis of the argument. Obviously, the court did not say those words, but that is the inference that statement gives off. And that is not what the standard is.
That is one interpretation of those words. Another could be that, gosh, the evidence was enough there that the evidence was of such weight that it didn't take this jury very long to have to make a verdict. I mean, you could read that either way.
And I think that the possibility that you could read either way is also one of the reasons why this is a problem, because we don't know. And I think that in order to ensure that the right standard was used, when there is a lack of the magic words or a lack of clear interpretation, then it needs to be reversed so that the court can reconsider the motion for new trial.
Counsel, that's what troubles me about your argument on this point. I get what you're saying, but it seems like the only way to craft a rule based upon what your argument is to say there are magic words that must be said whenever you're ruling on a motion for a new trial in a criminal trial. I don't know how you get around it.
And I do see that point as well. And I understand your Honor's position, but when there is such a lack, I don't think there needs to be magic words, but there shouldn't be any inference or even a possibility that the wrong standard was used. And the fact that this statement could be interpreted multiple ways, I think is the problem.
But if the rule doesn't provide that the court has to state the standard or has to make any findings, then this is what we're left with, right? I mean, unless the rule says that the court has to do that.
And I think that this situation would have probably even been better handled if the court made no comments at all, because then we wouldn't have this argument argument at all, because if the court had just denied it, the assumption would be that it was denied because the court weighed the evidence and found that the weight of the evidence supported the guilty verdict. And the fact that these statements were made, again, that's why we're here. There is no magic words, but there were words that were said that provide a concern. So I don't think that the rules is going to require magical words, but like Your Honor said, they don't even have to say any words at all. It's the fact that words were said that has created the issue.
Ms. Reese, just to let you know, you're coming up onto the 15-minute mark. So if you want to, you can keep going, but if you want to reserve your full 5 minutes, you probably need to come to a pause now.
I will come to a pause then, and I will come back shortly. Thank you.
All right, you've got your full 5 minutes in rebuttal. Mr. Chapman. So there you go.
Thank you, Your Honor. May it please the court. Todd Chapman on behalf of the appellee of the state of Florida. I'll start, unless the court desires a different order, I'll go ahead and go in the order that opposing counsel went and start with the JOA issue. And I want to go through some of what I believe are the key facts, and some of these will be duplicative of what Judge Smith brought out, but I think it's important to lay them all out in a sequential order. So the first thing is that there's no debate that the appellant and Mr. Tim were together before the burglary. There's the dropping off at the gas station, through the pings on the phone records. Those all show that they are together up until the burglary. And as Judge Smith pointed out, appellant traveled to Lakeland to switch cars. This is not somebody who needed a car. This is somebody who already had a vehicle, went all the way to Lakeland, gets a car, and has a story about using it for the probation officer. But obviously that's a significant factor.
I want to focus. Can I pause you right there, because I do want to focus on that. Why was it necessary for the state to get in the story, his story within the story that it was trying to show here about whether or not he was a conspirator in this crime? Why was it necessary to get that in, that he was on federal probation?
Well, on the probation aspect, as far as the telephone number, if I can address that first, I don't know if that was part of your question, but there was, and this is in the record, but not, I don't think really clear in either brief. As far as the phone number, the phone records were his phone. The phone he was using was not registered to him. It was registered to a Tim Johnson. That came out through the T-Mobile witness on page 49 of the record. Also, the state tried to get the phone number in through appellant's father, Ernest Cherry Sr. And that's an interesting, if you read the 6 pages, 175 to 181 of the brief, or of the record rather, it's clear that the father is saying, oh, this isn't his phone number. And it appears from the context that the state had the father in a prior hearing. He'd given them the phone, said, this is the number I had for the appellant, and he had switched it. So there was a real need to have the very clear form from federal probation to show what the phone number was.
Well, I understand you got to prove the phone number. I'm just trying to figure out why the story has to come in.
Well, I guess there needed to be some explanation as to why Ms. Bonaparte lent him the car. I mean, I think it would just be a kind of a hole in the sequence of the story to say, hey, yeah, he gave me a truck and took the car. I mean, there was no that was part, and I think they argued it was inextricably intertwined with the sequence of events to show why it was that he went to Lakeland to get the vehicle. Why was Ms. Bonaparte gave him the vehicle? So if I can just get back to the JOA argument, if I've answered that question sufficiently. So the one thing that was not mentioned earlier in the argument is the morning of the burglary, appellant calls Ms. Freeman and asks Mr. Freeman, and ask if the appellant is about that life. And that was given, and when was asked, what does that mean? Tim said Freeman said that would mean he was asking whether or not Tim would help in a fight. If there were 10 people involved in a fight, would he be there and fight? So I think the fact that appellant is making that reaching out to Mr. Tim's cousin the very morning of the burglary and wanting to know a little background. I mean, not that they've known each other a long time, but wanting to know, what this cousin's idea is of his, how he would behave if things went bad, I think is very significant. Also, one thing that is, I don't know, is clear in the brief is that at 11:46 on the morning of the crime, about 2 hours before the burglary, appellant's phone pings off of the Rivage Circle cell tower, Rivage Circle, that being the neighborhood where the burglary took place. So you have him there 2 hours before the burglary. And another thing that is very important is the surveillance video from the apartment complex. And watching it, it's not the easiest video to watch because there's kind of some dead time and you have to watch it a few times. But when you watch that, you'll see that the apartment complex was surveilled by the occupants of this white Grand Prix for 26 minutes. They make 2 laps or more around the apartment complex, and they back in to the parking spot with a view of Ms. Mallory's apartment and sit there for a period.
Mr. Chapman, that vehicle, you can't see Mr. Cherry in that vehicle, and the vehicle owner, Ms. Bonaparte, also couldn't identify her vehicle definitively. Would that be accurate?
She said it looks like my car, I believe, was Ms. Bonaparte, but she said she couldn't definitively say. I believe Ms. Mallory, when shown a picture of Ms. Bonaparte's vehicle, said, yes, that is the vehicle. I think Ms. Bonaparte was definitive in her testimony about.
You mean Mallory? You mean Mallory?
Yeah, Ms. Mallory.
Yeah, okay.
Not sure what I said. But the vehicle is there for 26 minutes. They're driving around. They're obviously surveilling the apartment complex. Backing into the spot, I think, is significant. Sitting there for 11 minutes. Another thing, I know there's a little bit of a dispute in the testimony about this, but Mr. Tim was seen by Ms. Mallory with these blue, I guess they were socks that he was using as gloves on his hand. She saw him before he actually came in the door. She saw him as he was exiting the vehicle, and he had these socks on his hand. So I think there's a reasonable inference that the appellant would have seen him putting these socks on his hands as he left the vehicle, which I think obviously is very suspicious activity. Then, as Judge Smith, you already pointed out, immediately after Tim was shot, I think at the same time that Ms. Mallory's calling 911, there's this call to Freeman. Then I think the phone pings will show him going to the spot where the car was abandoned, and it takes him there. And then he's not only does he say the car is stolen, he asks Ms. Bonaparte will you call it in? Will you call the police and say it's stolen? And I think there's some reference about, he didn't want to do that because he was on probation. There's nothing to say that somebody on probation can't report themselves as a victim of a crime. And, as far as the reasonable inference of innocence, that he just dropped somebody off, I mean, let's say he just was dropping him off and didn't know that. All of the activity that took place after the shooting would show his consciousness of guilt. He didn't call 911. He abandons the car, comes up with the story about the car being stolen, and then doesn't even want to report that. So I think the video and the phone records are very telling. There are, in the record, there's some screenshots of the video that show when and where the calls were made. I think that's significant. And if there are no more questions on that, turning to issue 4, the motion for new trial argument. First of all, the arguments were made at the appellant filed post-trial a motion for new trial, then a brief in support of a renewed motion for a judgment of acquittal. Those were argued at the same time. And as I think has already been indicated, the trial counsel for appellant very clearly set out what the motion for new trial standard was. And the judge obviously did not make a detailed ruling, but there's no indication whatsoever that he followed, or I believe it was a she, used the wrong standard. And as has been pointed out, as the Belesso case out of the Fourth Circuit makes clear magic words are not required. And as the majority in Bell said, magic words are not required. So if there was an indication that the judge used the wrong standard, that would be concerning. But there is no indication of that. The motion set out the correct standard, and trial counsel immediately before the trial court ruled stated the correct standard. There's no indication the trial court used the incorrect standard. If there are no further questions, the state asks that the judgment and sentence be affirmed. Thank you.
Thank you. All right, Ms. Reese, you have your full 5 minutes of rebuttal.
Thank you, Your Honor. Just a couple of points on some of the facts that Mr. Chapman was raising. And again, I think this just goes to the stacking of the inferences. The fact that the vehicle was seen, obviously driving around, the argument on the state's part is going to be that this was for surveillance and that there's some criminal intent behind that. However, as in a situation where we have no evidence of what was going on in that vehicle, we have no idea what was being discussed. We can't put that into context and offer that as sufficient proof of a plan or any sort of knowledge of what was going on. The other fact that was mentioned
what's your response to this, to the blue socks or whatever on his hands as he's leaving the vehicle? Miss Mallory says she saw that, and you have someone, a passenger in the car, leaving with the socks on his hands. What's your explanation for that?
So I think that that's an interesting fact, and I was going back and looking at the transcripts. So, and nothing on the attorneys that asked the questions, but I think that the questions were poorly asked. Miss Mallory was asked to describe what she saw, and she at first said that she didn't think much of it when she saw someone exit the vehicle. She said that she had seen the car sitting there for quite some time, and she just thought nothing of it, and she thought that the person was probably going to her neighbor's house because the way that they were set up, there was 2 doors in close proximity. And then after she gave that answer, she was asked by the state, can you describe what the person looked like? And that's when she said that she explained that he was bald, he had what looked like blue gloves on his hands. And I think that's why it wasn't the best asked question, because nobody ever asked her to clarify at what point she's describing. Was this what he looked like the minute he got out of the vehicle? Was this what he looked like when he actually got to their house? Because that matters. Why would someone be walking around in the middle of the day, light outside, with gloves on their hands? The more reasonable explanation, or if this had been clarified, would have been that he put the socks on his hands when he got closer to the door, which again, we just don't know because nobody ever asked her to clarify at which point in time she is describing this person. Because a reasonable, rational trier of fact would wonder why she was not concerned to see someone walking around with gloves on their hands in the middle of a Florida day, in the day after they had just been sitting outside their vehicle, outside her house for some time. So I think that is definitely not the most significant fact that the state had to support an inference or an assumption or an argument that Mr. Cherry knew what was going on. As to the motion for new trial, again, just reiterate that our position is that the wording used by the court is not sufficient to establish what standard was used. And alternatively, weighing the evidence, our position is that the court should have granted the motion regardless, especially in light of the comments that were made. So I would ask the court, if the court has no further questions for me, I would ask that the court grant Mr. Cherry's appeal and either vacate his judgment and conviction or reverse his case on the motion for new trial issue. Thank you.
Thank you. Thank you both. At this time, if you all could please exit the virtual